Tuesday, Reddy Neumann does bring in the business immigration updates. Emily, now we have the big news. Now the transition is officially on. We do have a USCIS chief that has been appointed by the Biden administration. Now, I just want to make sure, what does this Biden has for the business immigration? It seems that he has a lot of plans for the immigration, but when it comes to the business immigration, what plans does he have?
Not really much of anything.
What?
Yeah.
How can he be elected without business immigration plan? Did he not put anything on his agenda that he's going to do this or that, he's going to oppose, favor? Nothing.
Nothing for business immigration.
Well, I was expecting, a lot of people were expecting when the administration is going to change, a lot of changes are going to come in. So this guy doesn't have any plan so I'm going to ask a couple of questions related to some of the business immigration that is very important for especially our audiences now. What about the Senate 386 bill? If this bill that allows the per country quota, it eliminates the per country quota limit. It treats all the immigrants in one, in an equal way. It doesn't discriminate. It doesn't do anything. What about that bill? Does he have any policy on it?
Not that I've seen, and I don't think it's something he's against, but I also don't think it's something he's going to champion to try to push the Senate to pass.
How about the prevailing wage regulations that went into effect in October of 2020, which increased the prevailing wages for H-1Bs and green cards almost up to 40%. I mean, between 25 to 50% even on top. Does Biden administration has any plans to undo those dual regulations, though?
Nothing that's really been announced, and he's really more less pro-business, I would say, so he might be planning to just leave it in place rather than going through the regulatory process to block those.
What about the H-1B regulations, Emily, that are becoming effective, the new regulations that has a restriction on the specialty occupation, that has the restriction on the consulting companies filing a H-1B? They will be only getting a one-year approval, even if they have a contract for 2 years. Does this administration has any plans to undo these things?
No, not at this time.
Oh my goodness. Now, Trump administration has introduced the biometrics for all the people who are filing I-539 application. This is especially for the H-4 extensions, H-4 transfer, F-1s, L-2s. Even for a 3-year-old kid, they're asking for biometrics to get their H-4 or L-2 approved. Does this administration have anything to undo these plans?
I don't think so.
Oh my goodness. Trump administration has introduced the social media thing, where some people, if you are applying for a visa status, you have to disclose your social media in the visa application, and this has really caused a lot of problems. We haven't found a single terrorist because of that. We haven't found any bad guys. But what it created is a delay in getting the people into this country. Right now, the applications are backlogged by about like 4 to 5 months. I mean, to up to 6 months. Now, does the Biden administration has any plans to remove these things from there? Oh, that doesn't look good at all. Now, what about the fee changes that the Trump administration has done? Increase the fees significantly. In some cases, especially in the case of the adjustment of status, it has gone up almost by thousands and thousands of dollars, especially if you include the E-8 and advance parole fees. Of course, the court has put a restriction on it, assuming that the new administration comes in. Will they withdraw the new fees regulations, new fees, and go back to the old fees, or will they go with the new fees and still fight on in the court?
I think that they will replace the new fees with new fees, most likely higher fees for employment-based businesses and lower fees for naturalization and those that were greatly increased, and I think they tried to add a fee to asylum. Those are the types of things that he might.
So what you're telling is for the business immigration, it's going to be more punishment fees rather than actually more relaxation fees for ours. Emily, now because of the pandemic, some of the student visa people, they're studying from their home rather than going to college, because a lot of the universities are not allowing students to go there. People are also fearful with the pandemic. And these people, according to the Trump's order, they cannot go outside the country and visit India or whatever their countries are, come back. When Biden administration, there was a restriction on that. Mm-hmm. When Biden administration comes in, do you expect that restriction to be taken off immediately?
No.
Okay, well, so that doesn't look good at all. Now, there is a couple of other things that I want to discuss. These are all business related, and everything you said no.
Right.
Okay, let's speak about the things that are not business related, which are not important for our audiences, but I want to go, what about the border wall construction? Is this guy going to stop that?
I would expect that to happen, yes.
What about the DACA EADs that Trump is trying to restrict? Is he going to allow them to continue?
Yes, I do expect him to try to bring DACA back and probably expand it.
Now, how about the refugees? There are a lot of restrictions. People are being persecuted in their home country. They're trying to come in. There are a lot of restrictions put by Trump administration. Is Biden administration going to do anything about it?
Definitely, he'll reverse that.
What about these kids getting separated from their parents when they're in the, when they're entering into the country? Maybe they are unlawfully, they've been found to be unlawful, and the kids and parents are separated. What is Biden administration is expected to?
Yeah, I definitely think he will reverse that.
Emily, what about this public charge rule that was being bought by this administration? Even though it's not affecting most of our audiences, especially the business immigration, the paperwork is humongous, and it's just too much. And do you think Biden administration can do anything about it?
Yeah,
and if he does it, what's the reason why he does it?
Yeah, I think that is one area where he might, that might be one of the regulatory changes that are implemented rather quickly, but not because it helps employment-based immigration. It's more because that public charge rule really impacts family-based immigration. It makes it a lot harder for families to be reunited, and so I think he will relax those requirements, and it would hopefully benefit employment-based and having less documentation to have to put together, because that's almost worse than just preparing the adjustment of status itself, but not because he's trying to promote business immigration.
Emily, Biden administration has appointed Alejandro Mayorkas, a Jewish Cuban immigrant, as a lead for the Department of Homeland Security. Do you know anything about him? What kind of person he is? And what is expected to come under his control?
Yeah, I think this will be a welcome change. He was previously the head of USCIS at the time when DACA was implemented. So he was the one responsible for creating the policies, the processing for how we were going to provide EADs and approve DACA for so many hundreds of thousands of people. At the same time, while he was at USCIS, I think there was a much more intentional focus on customer service. It is the U.S. Citizenship and Immigration Service, and they were very good about providing customer service, InfoPass appointments. You could talk to a person when you called USCIS, and that was a major change that I felt when he came in to lead USCIS during the Obama administration.
Did you happen to meet him at any time?
Yeah, so he was actually, I think it was in 2012, if
that was in Tennessee?
A good question. I don't remember, but it was at an AILA conference that he did come to speak to all of the AILA attorneys that were at that conference, which is another positive thing, because right now there is no liaison relationship
no engagement
between
at all.
DHS and AILA, and so I think having Ali Mayorkas back at DHS will be very good for AILA to be able to kind of get those communications reestablished and work together to improve immigration as a whole.
Emily, there are new regulations that are becoming effective on December 8th. These regulations are restrictive on the specialty occupation, the consulting companies filing an H-1B and getting the H-1B approval. Can you comment anything about it?
Yeah, so the Trump administration fully plans to implement that next month. The good news is we have multiple lawsuits. One actually is already filed and pending and had their oral arguments yesterday, and I expect additional lawsuits to be filed specifically on this DHS rule.
Okay.
Because we have two different rules, and some of the lawsuits are seeking to block the DOL rule with all the prevailing wages, and some of the lawsuits are only seeking to block the DHS rule. So on the DHS rule, we have one already filed lawsuit that is brought by the U.S. Chamber of Commerce and universities and several large business groups, and they had oral arguments yesterday. This lawsuit is actually seeking to block both the DOL rule and the DHS rule on the grounds that they had no good cause to skip the notice and comment and go straight to the interim final rule. The arguments were yesterday on that, so we may be getting a decision soon from the judge there. That's the only lawsuit that's currently pending on the DHS rule that would take effect next month.
But what restrictions it's bringing, assuming that the court doesn't act anything on it, what restrictions, there's new regulations that are becoming effective in December 8th?
Yeah, the biggest impact will be the short approval period if you're in third-party placement, bringing back all of those RFEs about end-client letters and employer-employee relationship, right to control, as well as really narrowing the definition of specialty occupation so that fewer positions qualify as a specialty occupation, and also narrowing the types of degrees or the fields of study that someone can have to qualify for a position. So, I mean, I think it was Ken Cuccinelli who was, touting this new rule on TV basically saying, we think we can block 200,000 H-1B petitions from getting approved.
1/3 of the entire immigration
So that was
force.
ultimately what the goal was. So it is expected to have a huge impact if it goes into effect.
Emily, we have been informing the clients that if the student is on OPT and if they don't update their SEVIS system about their employment, their SEVIS system will be terminated. But luckily it seems that the ICE and the DSOs are giving chance in sometimes where they can correct the things if they update on the employment. Can you explain that once the student graduates, once they get an OPT, what are the things that students need to know?
Mm-hmm. Yeah, so during that first year of OPT time, you're limited to 90 days of unemployment, and you're required to update your school regarding any change in address or change in job, including unemployment. So you need to make sure that you're always updating your school whenever you have a job change, whenever you start work, whenever you end work, and then move on to the next job, and then they will start counting the days of unemployment to ensure that you don't exceed 90 days. So if you miss updating that you've started a new job, that counter just keeps going, thinking that you're unemployed that entire time. So that can have an impact on you and actually kicking you out of the SEVIS system without any kind of warning. Once you get into your 24-month STEM extension, it's got to be paid employment. It has to be at least 20 hours per week. You have to be working for an employer that's in E-Verify, have the training plan, and then also ensure that you're not exceeding the 150 days of unemployment time during that period.
Emily, questions are coming on the court hearing, especially a lot of companies, large companies, Emily, some companies, I don't want to name them, they have said to their employees, we are not going to file the extension until we get to know what's going on the prevailing wage. And now we have questions coming from Krishna from YouTube, and also on Ramakant from YouTube, and also MPKN from YouTube. They're all asking the same question. What's going on the prevailing wages of the H-1B? What court hearing happened? What are the updates that you can give at the court hearing?
Yeah, so on the prevailing wages, there are 3 lawsuits currently pending. The first one that I talked about a few minutes ago that had the hearing yesterday, that one is seeking to block both the DOL rule and the DHS rule. They had oral arguments yesterday that seemed to be quite in favor of I guess, against DHS and DOL, basically that they did not have good cause for skipping the notice and comment requirements of the normal regulatory process. So we could see a decision within a couple of weeks, perhaps, from that judge. We also have a lawsuit that was filed by ITServe and several companies in New Jersey, I believe. That one also had the initial arguments, and they're working on a summary judgment to basically, summary judgment means the case is so much in favor of the people who brought the lawsuit that they don't even need to go to trial on it, and they're just going to decide it without going into the whole merits of it. So that's a potential to happen in the next few weeks here. And then the American Immigration Lawyers Association has another lawsuit. I think that one is in, I can't remember where.
It's along with the Purdue University, is that the same?
Yes, I believe so.
Okay.
So that one, similar, they switched from having they were planning to have a hearing on the preliminary injunction, and instead they canceled the oral arguments and are moving towards a motion for summary judgment as well.
Let me explain the people that what this litigation main contest is, that when a regulation has been issued, there should be a chance for the people to comment on the proposed regulation, and the government is supposed to respond to those comments of why they think so it is good, why they think so it is not good, and then issue the final regulations based on the comments made by the individuals. Either the individuals or the companies. Now, when they did issue the prevailing wages, though, they just issued the regulations and they said they become final, and you can comment on that afterwards. So this is the basis for which most of this litigation, court litigation, is said, what's the need for you guys to issue a final regulations without having a notice and comment, without taking into consideration all these comments that people would have normally made. So that's the main contention, and that's where the government has to justify that why do they have to do it so immediately? Why can't they give a chance for the people to comment over it? That's where the weakness is for the DHS. That's where the asset is from the people who are contesting in the court. Correct me.
Exactly right. Sriram from Facebook wants to know, he applied for an H-4 EAD earlier this month, and is premium processing service available? Unfortunately, no. Although we do have a law that was passed that requires USCIS to expand their premium processing options to EB1C, providing it for H-4s and EADs. At this time, it has to go through the regulatory process to be actually implemented, and that regulatory process has not been begun. I don't expect that to happen during the remainder of the Trump administration, so we'll have to wait for Biden to come into office and for them to start that process. I think it's going to take time.
Mohan Babu has this question. What happens to the I-140 priority date if the 485 gets denied? Can the priority date be retained? Well, one major problem, Mohan, is that if the 485 is denied, there is a serious consequence for it. Why is it denied? Is it denied because most of the time it's because of the underlying I-140 problem. If the underlying I-140 has a problem, then there is a problem for the priority date. If the other reason is that if there is any criminal history, then maybe there is a problem for you to stay in the country. I would say that if the 485 is denied, I would just consult a lawyer to go over my entire file to make sure what are the things that you can and cannot do.
Vilakshmi from YouTube wants to know our opinion on the December visa bulletin. That is, a little bit of a not expected how it came out with the date for filing EB3 actually moving backward. And again, the filing final action date charts moving very slowly forward. We've said multiple times that no one can accurately predict the visa bulletin, so you shouldn't be surprised that it came out different than what we thought. But what can we learn from this? It tells me that probably USCIS received more EB3 downgrades than they were expecting, and by pushing back that filing date chart, yet still allowing us to use the filing date chart means that they still can accept more EB3 downgrades, but they don't want to take too many. So that's what they're trying to balance right now, because they have no way to predict how many people are going to downgrade. They don't know until that I-140 petition is filed. So I think that's why we saw that kind of unexpected little blip. And then once we see how many were filed, then they can better predict how much they need to move those dates for the rest of the year.
Questions that are coming on with regards to the per country quota limit and increase of the H-1B when the Biden administration is going to come in. One, for both the things, it has to go through the Congress. The parliament the parliament is called Congress in United States. In the whole world we call it as parliament, but they call it here as a Congress. So it has to go through the Congress though. The per country quota limit has nothing to do with the Trump administration. It has nothing to do with the Bush administration. It has nothing to do with the Obama administration. It has nothing to do with the Clinton administration. The fight for taking the per country limit has been there since the time of Clinton administration. I've been there, part of it, advocating to remove that from that time. So it has to get through the Congress, and that's where the hurdle is. If it passes through Congress, I have no doubt that the present president, whether it's Trump or whether it's going to be Biden, either of those people can sign this. There are still, we call this period as, what do you call this, lame duck session. That means that people are being voted out, but they still are in power right now until January 20th. There are a lot of things that can pass in lame duck session. So please keep your hopes up. And the one that is hindering right now is a senator from Florida. So please contact him. Scott, what's his name? Yeah, not the presidential candidate, Senator Scott. Please contact him. That's the one who is holding it. Things can still be passed before Trump administration goes out of power, and Trump can still sign this per country quota limit. So keep your hopes up and keep contacting the senators though. As far as the increase of the H-1B is concerned, Sandeep, this has to still go through the Congress. I don't think so. It is going to happen. They're not going to do that for sure, because it's a little bit more controversial bill. I don't think so it's going to go to the Congress, so don't have any hopes on that. Kranti has this question. Can there be an executive order removing birthright citizenship? Last week we presented with regards to the Trump administration. Before they go out of power, they can damage the immigrants as much as they can. Can he issue an executive order for it? Yes, but once an executive order has been issued, it can also be undone very easily with another executive order. So even if there is an executive order that will be issued, we do expect that Biden is going to issue another executive order to undo this executive order. Kranti, you may, and a lot of people might say, well, in the beginning, you went through all the list of the things with Emily, and Emily said, no, Biden administration may not be able to undo it, may not be willing or may not be able to undo it. Now, most of those things were passed as a regulations. They were not passed as an executive order, especially for the prevailing wage, especially for the restrictions on the H-1B. A lot of those things went through regulation changes though. Especially if it's a birthright, it's going to be very important. And the constituents of the Biden supporters definitely don't like those kind of executive orders. So Biden is going to immediately act on it as soon as he comes in. If Trump administration by any chance signs any of those things, I can tell that as soon as Biden comes into power, within 1 week, he's going to sign an executive order undoing it.
Sunil from Facebook wants to know about H-4 biometric appointment delays. How long should one wait before calling USCIS for a status on the appointment? Well, actually, USCIS had a stakeholder call with the Ombudsman office last week, and they provided some interesting and not great sounding statistics about these biometrics appointments. So first off, I believe there were still, now I'm going off the top of my head here, it has been a week since I heard these numbers, but I believe they still have 62,000 appointments that they need to reschedule that were canceled during the COVID-19 when all of the ASEs were closed. So they're already 62,000 behind, and they have about, if I remember correctly, 1.3 million that are still waiting for biometrics, and they can only take 10,400 per day. So they are a huge backlog. It's not going to be anytime soon. It does depend on the volume that they can take at your local office. They did say that they're trying to reuse biometrics whenever they can. We're not seeing that being very helpful for these H4s that are delayed. But yeah, it's a big problem, and it doesn't look like it's going to get any better anytime soon.
Question from Ajit from YouTube is that, will the prevailing wage will be based on the new wages, or will it be under the old wages? And he's also asking about the preliminary injunction. If the preliminary injunction that blocks the prevailing wage thing, then it will be according to the old wages. But as of today, Arjit, there is nothing that has blocked it, so it will be based on the prevailing wages that have been issued in the month of October. That means the new prevailing wage. So even if you have filed an application before October, though, they would still use the prevailing wages that came out in October. Even though you filed your prevailing wage in August or September, it will be the new prevailing wages that they will do, unless the court reverses this or puts an preliminary injunction. Question that is coming from Irshad. What about the unused green cards from the 2021? Will they go to the 2022? There are two things, Irshad, from YouTube. There is one thing is called family-based preference category. Just like the way employment-based preference category we have, they do have a family-based preference category. If the family-based preference, those preferences are called spouses of green card holders, children of green card holders, adult children of green card holders, married children of green card holders, brothers and sisters of US citizens. So those are called preference categories. If those family categories are not used, those visas will have to be given in 2022 to the employment-based. But Isha, there's also another thing. If by any chance the government is not going to use the employment-based green cards in this year, we have extra up to 100,000 that has been granted from the family immigration into business immigration, plus we have 140,000 that's already available. So if the 250,000 or 240,000 is not used, they will go into trash. They will not go to the next year. It's only the family-based immigration that is not used, preference categories will go. Yes, there is a good chance that some of them will be also coming next year, even if this administration wants it or not, the new administration wants it or not, because the Trump executive order is still there until January 1st of 2021, restricting the family immigration preference category to come in. The year starts from October. So we have October, November, and December. So almost 1/4 of the year numbers, most probably, unless the consulates very actively give the green cards in the remaining 9 months, those wasted green cards will be coming into the business immigration, though. Even if the Biden administration wants to do something, there's something called COVID right now that is restricting the fully opening of the offices and giving the green cards to the people. So still, there is a good chance that a number of green cards will be falling into business immigration coming next year.
Sunil from Facebook wants to know about receipt notices that are being delayed. He has an H4 EAD that was filed 3 weeks ago, and the check is still not cashed. So we are seeing some receipt notice delays, but it's typically in family-based immigration cases and all of these adjustment of status and downgrade cases that were filed in October. Not really seeing a lot of delay in H4 EAD receipts, so there may be a problem if the check has not been cashed after 3 weeks, but you can't really follow up with USCIS until it's been at least 30 days since the application was received.
Harish has this question that the USCIS doesn't have the capacity to process the 240,000 green cards applications. What is going to happen? Well, it depends on the new administration, though. I have seen that if the government wants to process it 240,000, they can. Especially when Bush administration came into power in 2000, I have seen action like anything. Now, this administration, now we do have Alejandro Mayorkas, who is coming as the Department of Homeland Security chief. If he intends to get these things processed, though, believe me, he can process these things so quickly. When Bush administration came into power, he said the processing time for adjustment of status at that time remained the same as what it is right now, almost 4 years in most of the country at that point of time. What Bush administration said is that he said reduce the timings in the next 6 months. You know what the government did? Government official did? They did nothing. They didn't improve. From 4.5 years, it went to 4 years and 9 months. You know what Bush administration did at that time? He said all the district directors are fired 6 months from now because you didn't act according to what I said. Guess what happened in that 6 months? The 4 years and 9 months processing time came down to 3 months. We begged the USCIS, please don't adjudicate the application so fast, because administratively there are certain documents we need to collect, especially if their wife and husband living together, documents we have to collect, and we couldn't collect enough documents because there is not enough living together documents. We want some time. Give them in 6 months. Don't give them in 3 months. This is a request we made on behalf of our clients. Yes, if this administration wants to, they can get in this application processing time from 4.5 years. They can come into 3 months. We request them 6 months, but they can get it down to 3 months. I have had to go to interviews Sunday morning, Saturday 6 o'clock, Saturday 5:30 in the evening. I mean, we have to go for the interviews at that time. That was the situation there. Yes, if this administration want, they can. Now, if they don't want it, then it's going to be the same administration what we have seen before, because they didn't want to give the green cards.
Joyo from YouTube wants to know if an I-140 can be filed for both EB2 and EB3 at the same time after a new PERM approval. Absolutely. Yes, if you are going through the PERM process now and your PERM has been filed for a position that qualifies for EB2, meaning that the job requires at least a master's degree or a bachelor's degree plus 5 years of experience, once you get that PERM approved, you can file 2 I-140s at the same time, select one in EB2 and one in EB3, get both approvals. Only one of those can be filed in premium processing because you only can have one original of the PERM. But other than that, yes, and that's something that I think more and more people will be doing as we see flip-flop happening between EB2 and EB3.
Ali from YouTube has this question. I have a master's degree. Will EB3 will be denied because I'm overqualified? Overqualification cannot be the cause for denial of the H-1B or I-140. That is there. Never seen anybody getting denied because they're overqualified. Absolutely never seen.
Arjit from YouTube wants to know if a PERM prevailing wage determination.
I already addressed
you
this.
did?
Yeah.
Okay. Suman wants to know, for the GC, EAD, and AP to be approved, do the biometrics need to happen prior to, or is this approval independent of biometrics? I have seen within this year EAD and AP being approved without the biometrics being done, and then they send biometrics later, generally for the 485. So I don't think they're tied to each other.
Yeah, and a lot of people also ask question, is the I-140 tied to the EAD and AP when you file an I-140? Even if your I-140 is still pending, they can still adjudicate the EAD and AP application. It doesn't matter. They will still adjudicate the EAD and AP. A lot of questions are coming with regards to the portability of the 485 application. I want to explain that once you file the 485 application, after 180 days, if you change the job, the new company has to file a 485J supplement. And we may have a separate video specially made in the next 2 to 3 weeks. We'll make a video just for this portability issue. At this point of time, what I strongly recommend people is that do not port until 180 days after your 485 application has been filed. The new employer has to file a 485J supplement to port. They have to sign it and send it out to the USCIS. If you are a downgrade application where your I-140, or if your I-140 is still pending though, do not port. We strongly recommend that you wait until the I-140 is approved. The second thing is that you may want to wait until 180 days after the I-140 has been approved. That's the second condition. This condition is not an absolute requirement. This is just our recommendation that you wait until I-140 is approved, plus 180 days before you port the date to a new employer. And new employer has to file the 485J supplement. If the USCIS finds that you are not working for the company which filed the 485, they will automatically deny your 485 application. How would they come to know? Normally what happens is that when you move from company A to company B, the company A withdraws the I-140. A lot of people will say, oh, company doesn't have an authority to withdraw after 180 days after it's been approved. No, they do have an authority to withdraw it. It may not affect you, but they do have an authority to withdraw the I-140. So in the case when the I-140 is withdrawn by company A, the USCIS looks into the application. Hey, the 485 application is there. There is no employer other than employer A through which you file the 485 application. So they will deny the 485 application. It's going to be a nightmare to undo the entire thing, and it's going to cost you humongous amount of money. That's the reason why you need to have a 485J supplement filed by your new employer. The one good thing about this 485J supplement, even though I don't recommend it, but do you have to file a 485J supplement before joining the new company? Technically, it's not required, although I recommend that you do it, but it's not an absolute requirement that you have to file a 485J supplement before you join the company. You can do it after a week or 10 days after you join the new company.
Vineet from YouTube has applied for the I-485, and USCIS received it October 31st. Of course, no receipt notice issued yet, and now his priority date is retrogressed, and he wants to know what will happen to the application. So assuming that it was properly filed and received by October 31st, you'll get your receipt notices. USCIS will continue to process your application. The only thing they can't do is approve it until your final action date becomes current.
I may want to back off on that. October 31st is a Saturday, I believe.
Ah, that could be a problem. Yeah, typically it has to, if it gets delivered on a Saturday or a Sunday, it's not considered received until the following business day, which would be after the deadline. So that could be an issue.
Avinash has this question. Do you recommend a lawyer for N400 filing and for interview? I can't answer this question, Avinash, but I can tell you, if I were you, okay, not an immigration lawyer, but you, I don't have any criminal records. My English is good enough, and I have never traveled outside the country for more than 6 months at any period of time. If I were you, I would not use a lawyer.
Meenakshi from Facebook wants to know, what is the current PERM processing time? We're starting to see these approvals taking 6 months now, so they are continuing to increase. Amit from Facebook has an H-1B expiring this April and is planning to wait until we have a result on the December 8th regulation litigation, and wants to know if that's the right thing. I don't see any harm in waiting, especially if the litigation is helpful and eliminates these regulations. You do have all the way up until the very last day before your case expires in order to get that petition filed. So there's no huge reason to rush. However, in general, we also recommend filing early because of long processing time. So if you're going to wait, you may want to be sure to file it in premium processing so that you can get the result before your current petition expires in April. Because if it is denied after your current petition expires, it puts you immediately out of status. It's very difficult to get back into status in that situation.
SS from YouTube has this question. There are rumors flying around with regards to the EB2 to EB3 downgrade denials. As you cited, there are rumors. We have said many times, we have filed many applications, we haven't seen any summary denials. There was one American immigration lawyer that published, that sent out a kind of text message that was a message posted in an Immigration Lawyers Association, which actually they are not supposed to post that thing outside. And it went viral in the WhatsApp application, and a lot of rumors were spread around that EB2 to EB3 downgrade is going to be denied without anything at all. That has proven to be a complete wrong. That particular lawyer who sent that thing sent the downgrade application, 485 application, to the wrong address, so they denied it. We haven't seen anything like that at all. We have started getting receipt notices for the downgrade applications also. We haven't received any denial as of yet, none.
Harish from YouTube wants to know if you're allowed to travel while the advanced parole is still pending. Short answer, it depends. So note that if you do travel while your advanced parole pending, the current policy is that the advanced parole will be denied, and once you come back, you're going to have to file it again. So that's number one. Number two, there are only certain statuses that allow you to travel outside the U.S. without the advanced parole, without abandoning your green card application, mainly H and L statuses. So assuming you are currently maintaining H or L status, you'll go out and come back in H or L status, then you can travel, but your advanced parole will be denied. But definitely check with your immigration attorney before making any travel plans.
Hema Singh has this question. Her kid is 17-year-old. Can he use the EAD? I'm assuming that you're speaking about the adjustment of status EAD. Hema, we recommend that your kid does not use the EAD. The reason is that there are two things. There is something called filing dates, and there is something called final action date. If your final action date becomes current, though, I don't have a problem your 17-year-old guy using the EAD. But if the filing date becomes current, if the filing dates are current and not final action dates current, and your 17-year-old guy uses the EAD, that means that he kicks his H4 out. Then we consider that he is married to this adjustment of status. And what happens is, according to the law, if your son turns 21 before the final action date becomes current, and there are some little exemptions for the time period that the I-140 has been pending, and if he doesn't meet it, then what happens is that he will be kicked out of this application. So if he turns 21 and the final action date does not become current, and he gets kicked out of this application, he can't just go to a student visa, because from adjustment of status, there's no way you can go to the student visa. And I will tell you in your language, Hema, because I see that you speak Hindi, that if your kid becomes 21 and the final action date does not become, your son will be na garka, na gatka. I have to use the Hindi sentence for that. That will be the major thing that you need to consider before you use the EAD.
Ashit from YouTube wants to know if the final action date will catch up to the date of filing before the fiscal year ends in September 2021. That is the whole intended idea of these dates for filing chart. It's in October, the Department of State predicts what they think the final action date will be. They're predicting that within the next 12 months, a green card will be available for these people, and this is the date for filing chart. That means that the final action date chart should slowly move forward and eventually meet that date by the end of the fiscal year, which is next September. Will that actually happen? Nobody can predict that. Because we have no idea, again, how many people are actually going to downgrade until they file the downgrade. USCIS does not have a way to determine who is actually in the pipeline, because so many people have multiple I-140 approvals. There's just no way to accurately tell how many people might file based on how far they move the dates forward. So that is what it's intended to do, but there's no guarantees that that is actually going to happen.
SS has this question. While his wife is in the 485 application, if his wife moves from H4 to H1, will it have any impact on the 485 application? The answer is If she is not married to the adjustment of status, which you want to know the definition of the marriage, I want you to go back to 1 month ago. Our YouTube, we have refined what a marriage to the application. If your wife is not married to this 485 application, she can move to H4 to H1, and that will not have no impact, none whatsoever at all, on this 485 application.
Sanskriti wants to know, how can you get an InfoPass appointment? This is from YouTube. That is the question of the last couple of months, because USCIS has been changing its phone system. They've gone to this InfoMod procedure where they don't allow you to schedule your own InfoPass appointment by going to the website. Now you have to do it through customer service. And now they've changed the telephone prompt, so we can't even figure out how to get in touch with a live person when you call the 1-800-USELESS number. So unfortunately, it's very difficult right now. You just have to keep trying. The only way to get an InfoPass appointment is to call customer service and actually talk to a real person. And then you have to be able to get them to agree that your situation is such a dire emergency that they must grant you that appointment, because they are so limited.
Ritesh has this very interesting question, is that does same I-485 portability rule apply if the 485 was been filed by the previous employer? I'm assuming, Ritesh, what you're speaking about is that currently you are not working for the employer that filed the 485 application. In that case, does the 485J supplement portable rule applies? Yes, it applies the same way. The only difference here is that the offer of the job must be existing for at least 180 days after you file the 485. So if the company A filed the 485 application, you're not working for the company A. And if you want to, after 180 days though, if you want to have some other employer substitute into the 485 application, you can file the 485J supplement and substitute. There are some caveats I would definitely discuss with a lawyer, because recently, before Trump administration has going out, they made some changes to the 485J portability issues of the 485J supplement, where they will look into the intention of your company, intention of you at the time of filing the 485 application, whether you intend to join, whether the employer intend to take you. That will be considered. So it's a very serious consideration though, that if you don't join, it may be looked into negative, although we haven't seen any denials, but I will be very cautious. Try to document this, make sure that you have the information where you were willing at the time of filing application, the employer was willing to take you. Those things need to be there before you move to a different company in the portability.
Naveen from YouTube, his wife has a valid H4 visa till next year, but last time she entered, her I-94 got cut short due to the issue with the passport expiring. So she luckily noticed it and filed the H4 extension. He wants to know how long it's taking for the H4 extension. Well, if you are have the unfortunate luck of going to the California Service Center, I think their posted processing times are now 15.5 to 20.5 months for a simple H4 renewal. It's not going to be a fast processing. The other service centers are not that much better, but I do want to make sure people are aware that if your passport is expiring before your visa expires and you're entering the country, CBP will shorten your I-94 when they issue that new I-94 electronically. They'll shorten it to your passport expiration. You have to make sure that you take care of that before the I-94 expires. So always, 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 when you travel and come back, immediately go online and check your I-94 to make sure what the end date is, and ensure that you take action to extend that before the date expires. A lot of people don't realize it when their I-94 gets cut short and end up overstaying. There's not a good way to solve that other than traveling, and you have to be careful to not exceed too much time after that I-94 expires.
Gajanan from YouTube has this question. He wants to know at what time he can start inquiring about the AO's receipt notice. Gajanan, what we have noticed is that right now, if you have filed your adjustment of status in the month of October, do not try to inquire about it. We have seen a lot of delay. Recently, the USCIS has informed the American Immigration Law Association it's taking about 6 weeks, but according to American Immigration Law Association, which we are all part of it, where we put our numbers out there, it's about 8 weeks backlog right now. That's the normal backlog that's there. But if you have filed your 485 application in September, though, and you still did not receive it, I would inquire. But if you filed in October, I would not inquire.
Suyash from Facebook wants to know, how can we request the new administration to use the filing dates instead of the final action date for the Child Status Protection Act?
Wow,
that's a great question. It's something that's going to be impacting so many people as the dates move forward and more people are able to file the 485. I think that you should contact the USCIS Ombudsman. I think that you should contact your congressman and ask your congressman to pressure USCIS into making that change, and you should contact the media. Start getting, raising awareness of this issue, because it is such an area that nobody knows about. I can guarantee you people are not familiar with it. Even people that are filing their applications are not aware of this issue. So if you can raise awareness, make people understand how hard it's going to be for these kids if the final action date doesn't become current in time, even though they've followed all the required steps, did everything properly, filed the adjustment, and you still can't get a green card just because of luck in the dates.
I have had a girl come in, Emily. She was 22 years old. Her mother got the green card, father got the green card, 2 siblings got the green card. She did not get it. Poor guy was crying.
Mm-hmm. Yeah, it's really tough. I mean, when you're at that age, you no longer have the option of being a dependent on the parent's visa type, and now you're breaking up families for no reason other than because of this policy that they made. So it definitely needs attention drawn to it. Hopefully the new administration can change that. And if we can solve the retrogression, we can get S386, all of these things combined are what are really going to make a big impact for so many people that are dealing with this difficult situation.
Mark has this question: can I work as an Uber driver on a regular H-1B job? No, you can't work as an Uber driver.
Madhu from YouTube wants to know, what is the possibility of the rejection of the 485 due to a DUI, for example? It doesn't necessarily mean that it's mandatory that the application gets denied. I think there are a lot of issues that USCIS is going to look at. How long ago did it happen? What they're really going to be concerned about is, do you have a mental issue with alcoholism? Is that, and that's something that they can deny the 485 for. But definitely it is something to consult with an immigration attorney about before you file.
What do you recommend, guys, for May 2020 EB2? Do you downgrade or continue on EB2? Naveen, since you already filed the adjustment of status, if I were you, I would not downgrade, and that's me. I may go wrong in this one, but that's what I would do if I were you, because you're doing an extra process of downgrading. I would not do if I were you.
Amit from Facebook has an H-1B expiring next April and wants to know if he should file the extension now or wait till the new president takes over. Good question. I don't think it makes much difference, honestly, because the new administration is not going to be able to make any major changes that quickly with the employment-based immigration. So I think what's more likely to be helpful is the several lawsuits that are seeking to block that regulation from taking effect. So if that happens, that would be helpful, but I don't think you can expect a huge change in the culture of USCIS. It's going to take a long time for Biden to undo what the Trump administration has done.
question is, second. A lot of questions are coming, Emily, with regards to the H4 premium processing, EB1C premium processing, EAD premium processing. When do you think so this will become effective?
I don't expect it to be done anytime in the near future. I would give it a year from now because we need the new administration to come in. They're going to take a good 6 months to revisit all of the different agency regulations and start to prioritize what they're going to put on the regulatory agenda, and then they can start to propose new regulations and then go through the regulatory process, which is probably going to take a good 6 months. So I think it's going to take a good year for that to actually happen.
Krishna has this question: can two employers file for the same employee with two different SASC codes? Will that cause any problem? No, I don't think so. It's going to cause any problem. Absolutely not. I mean, so, you know, one person may like you for a different position, one person may like you for a different position. There's nothing wrong in it.
Gopi from Facebook wants to know if there's any risk in filing the LCA under wage level 3 when it was previously filed 2 years ago under level 4 for the same job. Yes, there's a huge risk because the job hasn't changed. So if you decided that the job met wage level 3, it requires level 3 due to the complexity of the job, what the duties are, what the required years of experience is, what the education requirement is. If level 3 was correct 2 years ago, level 3 is still correct now. You can't simply reduce the wage level because the prevailing wage is too high.
Omar has this question: when do you think so that the stamping in the H-1B will be resumed back to square what it was before? It's going to be very hard, Omar, because the new administration is a little bit more restrictive in opening the offices as compared to the current administration. So we don't know how they're going to act. Are they going to proactively make Zoom calls where people can interview the people, or do they require people to come in? Do they have people come into a different office where they can have a supervised Zoom call rather than the things? We don't know. I mean, it's a pandemic situation. Some organizations have evolved and some organizations have not evolved, especially the batch of people that wrote the bar exam in our office, 2 of them. They have to all book a hotel room. They have to open the doors and they have to sit in the hotel and then write the exam. Each person will sit in the hotel room and write the exam. They have created some innovative things in getting the bar exam written. A lot of people have done different things. You know, Emily is planning for an office lunch. What is office lunch? We're going to all have a lunch in Zoom and then just eat the food. I mean, that's the way that she planned it for the office lunch. So this administration can come with some creative ideas, and then maybe they can have people go check in a hotel room and then have them there in the Zoom. I don't know, they can do a lot of creative things to cut down the time, and then also personal interaction if they don't want to have a personal interaction. So it depends on the will of the new administration. Are they going to behave like the way what they did when Obama was there? He wasn't that good, believe me. He was not Bush. So if he goes and behaves like the same way what he behaved before, we may not see much changes coming out. But if he behaves like the way what Bush did it, that's going to be significant changes. If he's going to behave like either Trump or he's going to behave like Obama, we're not going to see much improvement in the stampings.
All right, well, I think we're about out of time for today. Thank you so much for joining us. We'll be back next Tuesday. If we didn't get to your question, remember we do have a daily conference call where you can dial in. Go to rnlawgroup.com for the time and number for that. And if you want more specific guidance on your specific circumstances and situation, you can always set up a consultation with us or any of our attorneys here at Reddy Neumann by going to rnlawgroup.com.
Thank you, guys.